You won the arbitration, the award is final, but the Vietnamese party hasn't paid. Now you face the second challenge, turning that decision into real money. In Vietnam, foreign arbitration awards are not automatically enforceable. They must be recognized by a Vietnamese court through a formal legal process. In this video, we walk you through that process, explain common pitfalls, and show how LTS law helps foreign companies succeed where others get stuck. Yes, but it is not automatic. Vietnam is a party to the New York Convention, so a foreign arbitral award can be enforced in Vietnam through a court recognition process. In practice, this means you must file a request with the competent Vietnamese court to recognize and allow enforcement of the award before the civil enforcement authority can act. Awards issued in major arbitration hubs, such as Singapore, Hong Kong, London, Paris, and others, are commonly brought into Vietnam under this mechanism. As long as the award and the procedure meet the applicable legal requirements and do not fall into refusal grounds recognized under the Convention and Vietnam civil procedure rules. Your first step is to file an application for recognition and enforcement with the competent Vietnamese court. In practice, this is usually the provincial-level People's Court where the award debtor is based, or where relevant assets are located in Vietnam. The dossier is procedural and document-driven. At minimum, you will need a duly certified award, a duly certified arbitration agreement, and a Vietnamese translation that is properly notarized or authenticated. Depending on the case, the court may also review whether the parties received proper notice and had a fair chance to present their case, so preparing supporting evidence early can prevent delays. Vietnamese courts do not rehear the dispute. Instead, the court focuses on whether the foreign arbitral award meets the legal conditions for recognition and enforcement in Vietnam. In practice, the court will review key issues such as jurisdiction and the validity of the arbitration agreement, whether the parties were properly notified and given a fair chance to present their case, and whether the award conflicts with Vietnam's fundamental legal principles. If the award falls into refusal grounds recognized under Vietnam's procedural framework and the New York Convention, the court may decline recognition. This is why a well-prepared filing should proactively address the common refusal arguments from the start. The debtor is formally notified of the recognition filing. They may submit opposition, arguing improper notice, arbitration irregularities, or conflicts with Vietnamese law. We pre-review potential debtor arguments and submit a structured counter-defense as part of the original filing. Most debtors attempt delay tactics here. We neutralize them before they appear. In straightforward cases, recognition and enforcement can often be completed within around 3 to 6 months from the time a complete dossier is accepted. However, the timeline may extend if the court requests additional documents, if cross-border notarization and legalization takes time, or if the debtor actively contests the case. For foreign creditors, timing matters because once enforcement pressure becomes visible, debtors may try to relocate or conceal assets. That is why parallel asset tracing and early enforcement planning should be done while the recognition process is moving forward. Once the court recognizes the award, it becomes enforceable like a Vietnamese judgment. We then file with the Civil Judgment Enforcement Agency, identifying bank accounts, land assets, or inventory to seize. The stronger your pre-enforcement intelligence, the faster you recover funds. We map this process from day one, not after recognition is complete. A Hong Kong-based manufacturer won a $2.2 million US award under ICC arbitration in Singapore. The Vietnamese buyer refused to comply. LTS Law filed a recognition petition in Ho Chi Minh City, pre-translated all evidence, and anticipated the debtor's jurisdictional objection. The court recognized the award within 4 months. Enforcement began 2 weeks later, with property liens filed in Binh Duong and a 68% recovery secured within 60 days. Foreign parties often assume recognition is a formality. It's not. Mistakes include 1. Relying on non-certified translations, 2. Assuming arbitration laws are universal, 3. Filing in the wrong court. And 4. Ignoring debtor delay tactics. Our advice: never let your overseas counsel manage Vietnamese recognition alone. Use a local team who knows the system. You won the arbitration, now finish the job. If your company holds a foreign arbitration award against a Vietnamese party, contact LTS Law today. We'll evaluate enforceability, prepare filings, and pursue asset recovery, quickly and legally. Visit lts.com.vn to convert your award into real results. Because in Vietnam, justice must be recognized before it can be enforced.